Hi guys, good evening, and I welcome you all to
Hi
IMFG.
guys, good evening, and I welcome you all to INS.
So guys, today we'll be discussing about the weekly and like fortnightly important legal news. And we have picked today three topmost news from the last 15 days. So we'll be going ahead with that. So please stay connected, stay tuned, and we'll be starting soon. So the first very important affair is about the gender neutral restrooms and the online appearance slip. So in a very historic event, we have come to know that Supreme Court has brought this thing. Our legendary Chief Justice of India, D.Y. Chandrachud, has approved gender neutral washrooms. So approximately 9 washrooms has been approved now with this, because there was a request by the certain advocates that there has to be a gender neutral restrooms. So this will be constructed at different locations in the main building as well as in the additional building. So there are multiple complexes in the Supreme Court. So in all the premises of the court, there are 9 restrooms which will be made available. So this is a very big move, because so far we have come to know that this community, LGBTQIA community, has been suffering and has been struggling to gain their rights. So in that particular area, this is a very great news. Along with it, there was another thing, that is online advocates appearance portal. So this has been launched by the Apex Court last year. So now this has also been made gender neutral. So in the time of COVID, we have seen that the people had been facing this issue that they need to appear online. So in order to rectify that, the court has come up with this online advocate appearance portal so that the advocates can appear online in the court of law. So that has been solved, and that has also been made gender neutral. So these are the two very landmark thing which has happened from the Supreme Court. Senior Advocate Dr. Menaka Guruswamy. So this is an important name to note. So Dr. Menaka Guruswamy has been added as a member of the community. So the community, the Menaka Guruswamy will represent the queer community. So it is important that the representation for queer community shall also come into the picture, because so far we have seen that the representation has come from the other communities, because there are representatives which has been reiterated by the court of law. Now in this scenario, it is again a very important thing that a representative has been appointed by the court of law, so that the queer community can be represented and nobody shall be left. So this is a wholesome initiative with which the court will ensure the holistic development of our society. Then a proposal to rename the Gender Sensitization and Internal Complaints Committee. So actually a committee existed who has a name, that is Gender Sensitization and Internal Complaints Committee. Now the name will be changed, and the name will be Gender and Sexuality Sensitization and Internal Complaints Committee. So the purpose is that the scope may be broadened so that we can include everybody. So far, when we talk about internal complaints committee, we find it in the colleges also. Almost all of the colleges have this internal complaints committee, disciplinary committee, in which we deal with multiple issues which are related to the different genders. right? So now this has been the proposal has been given so that it can, the view can be broadened, the scope can be broadened, and further community can be involved in this. So this was coming from the Supreme Court directly. Now it is important to understand about this community. We have seen from very beginning that this particular community, LGBTQIA. So we have seen that this particular community has faced a lot of social issue, a lot of psychological issues in the society. So in the recent past only, we have seen that because of the multiple Supreme Court judgments and a long legal battle, this community was able to secure certain rights. So it is very important to go back and to understand from where this society is coming and how long they have fought this battle and what are the multiple implications and how really we are concerned about this. So we need to understand the legal and the social background as well. So when we talk about LGBTQAI, the acronym stands for lesbian, gay, bisexual, transgender, queer, intersex, and asexual. So this is the whole set of acronym. Now, the purpose is, so initially when we started, year back, it has been only known as LGBT, and later on different sorts of community have been added into it. So this is the purpose, that it needs to be strengthened, it needs to be broadened so that people can be given more freedom, more independence as what they want to select and what they want to choose in terms of their identity. So identity is a crucial area here, that we need to understand that we have a right over our identity. So different judgments have come across, and even in other countries also, like Europe and then United States, UK, Canada. So different countries who have already taken a step over this identity crisis, and we are running behind. So we have seen that this National Legal Service Authority versus Union of India. So this judgment was decided by two-judge bench back in 2014, and they declared transgenders as the third gender. So we have seen that whenever we used to fill the application form for anything, whether it's competitive exam or any other thing, even for applying for a driving license or Aadhaar card, we have seen that there are only two options with respect to the identity, either male or either female. Now gender identity has been broadened after this particular judgment, which was in 2014, and third gender was also got added. So this really affirms about the fundamental right. Now this goes back to the concept of our constitutional values, where the fundamental right has been given. Now, it is interesting to understand that our articles of Indian Constitution, whether we see Article 21, whether we see Article 14, which talks about the right to equality, which Article 21 talks about right to privacy. In this, there is no gender specific mention, right? So it does not say that men or women or males or females. So the constitution looks after a holistic development, and there is no gender boundary described. So in that sense also, the LGBTQ community has a right over certain issues, has a right over certain social agendas. So that is why we see that the constitution uses the word people, or the constitution uses the word citizen. So when we talk about such a broad area, it will be wrong to limit it to the men or to male or female. So that is why back in 2014, the Supreme Court gave this judgment, which led to the inclusion of transgender as a third gender. Then again in 2018, a very landmark judgment came, that was of Navstet Singh Johar versus Union of India. So on 6th September, 5 judges bench of the Supreme Court held that Section 377 to be unconstitutional. So Section 377 talks about the intercourse which is non-natural in nature. So any intercourse which is non-natural in nature shall be held shall be held liable as per the section 377 in the older times. So this law was held unconstitutional in 2018, which was very recent. So imagine that even after getting independence, it's been 75 years that communities in India are fighting for their rights because of a tussle between religious views and the constitutional views. So religious views and social views. So there are a lot of tussle in between different philosophical point of view with which it is impossible to give right to a huge set of community. And that's why we have been seeing that what sort of troubles and what sort of challenges this particular community has been facing. But with this prominent judgments, and even we had a very landmark judgment in 2017 that was of Justice Puttaswamy, and which gave us the right of privacy as a fundamental right. So for everyone's understanding, fundamental right in constitution has given a very special status because fundamental right is for all the citizens. So in this scenario, having this as a fundamental right is very special because the fundamental rights are enforceable in the court of law. So if any point of time we think that our fundamental right is getting violated, for example, to quote that until 2021, all of us might be knowing that women did not have a right in army. So this was a great issue that women did not have been given position in the army because of the section 12 of Army Act 1950, which says that women cannot be given the post of permanent commission in the Indian Army or in the Indian Navy. So again, a long battle has been fought by the women of our country for the past 10 years, after which in 2021, the court was finally able to give the verdict with which women will also be included in the army now. So it is important to note that a woman, which is a much more mainstream gender, a much more mainstream community who has faced a long legal battle or who is still facing the social and legal battle for this particular employment issue. It is important that we need to understand that imagine how long the battle for transgender communities may go, right? So but it is not a legal area which really changes or which really gives the right, but it is the social and the psychomotor domain of the society which really accept. So the problem with the current structure about the LGBTQ is that our legal structure does not grant them the proper right, A, and B, our society is also not ready to accept this particular change. So one example I will quote, that is the definition of family. So in the recent development, when the people from the same sex marriages wanted to have themselves as a family, wanted to expand their members as a family, the court denied so because in our Hindu Marriage Act, it has been said the family means one which is coming from blood relation. And it is obvious that the same-sex marriages are not coming in the lineage, are not coming through the blood relation. So therefore, they cannot be called as a family. So these are the pertinent issues which this community has been facing for a long time. And when we see what are the different problems faced by them, it is a social discrimination for obvious reasons. We have seen so far that how this community has been facing issues with respect to the employment, issues with respect to the entry into the certain public areas. Still people have fear in their mind to interact with this community, right? So we have seen a sort of disgust which is being expressed by the general members of society, a general club of society. So this is a very problematic situation because of which this community is not able to come forward. B, lack of representation. As I did mention in the previous slides, that this community has been facing a lack of representation. And that's why it is important to note that a member, Dr. Menaka, has been appointed as a representative for this community because of this particular issue that this community had no representation. And it is very important that someone should represent the community so that their voices may not go unheard. And again, mental health issue, since they are facing a lot of discriminatory issues, it is very common that they might come up with the different mental health issues. And again, to address those issues, there are still different problems which exist. So ultimately, they suffer physically and mentally both. And then the point of homelessness. So they are facing problem, they are facing troubles in getting a proper home or proper shelter, because again the problem arises because of the social disparity. So all of these issues are there which this LGBTQIA community is facing, and the solution could be the very friendly policy must be developed by the code of law, must be developed by the government, with which this community can come together with the general parlance of the society. So we are looking forward, we are expecting from the Supreme Court, and as we heard this news, it was a really great that the Supreme Court is working, because Supreme Court has been given the responsibility of maintaining and ensuring the justice. So this news has been a step ahead of providing justice to the LGBTQ community. If any doubts regarding this or any comments, please write down your comment. Then the next is hampers open justice. So Supreme Court has given strong remarks on the sealed cover. Now, I would like to tell you as a general fact that there are certain issues when it is represented or when it is going into the code of law, it goes under a sealed cover. So we present the matter under the seal cover so that it cannot be going to the public. Now, this trend is going to be changed from now onwards, because Supreme Court has given a strong remarks that in every matter the sealed covers cannot be used. So we have seen that how our legal system is emerging, how our Supreme Court is emerging from the upcoming different policies which court has taken. So this is one of them, as we have recently seen that Supreme Court has evolved a new policy that they are increasing the number of restrooms, they have opened the online portals. So with this, Supreme Court is also trying to make the justice more transparent, because we have seen that government has always, or government has mostly been biased towards particular party or toward particular groups or toward particular sect of people. So on the contrary, the Supreme Court or our judicial system is entrusted with the particular matter of ensuring justice or to make the justice transparent. So now the court had said that government cannot take this blanket of national security at all of the time, and particularly it was rejected by the Supreme Court that this is not a solid ground, or this is not a strong ground for presenting the matter in the sealed cover. So Supreme Court has said that even there is no evidence of terrorist link out of here, and especially when there is no such thing which can harm, which can provide or give harm to the national security, it is understood. But in this matter, there is nothing as such which can harm the national security, and thus putting it in the sealed cover is not right. So the court has clearly mentioned that the blanket immunity will be removed and the government has to present it in the normal manner so that it can be made transparent, it can be made open to the public, and public shall also come to know about the certain issues. Right. Why? Because it is important to understand that there are certain rights and freedom which has been given to us. So superficially, we say that we are a democratic country. So when we use the word democracy, it means that the government has been made by the people and government is for the people. So this implies that this philosophy of democracy implies that people should have an access to the government. But sadly, in the past 75 years, we have seen that the people are different, government are different, aspirations of both people and government are different. So all of us are now comfortable with the words like vote bank policy. Now, when we come across this word vote bank policy, it clearly indicates that how government is motivated by certain factors and how government is just looking for a vote bank. So the government needs us for vote and nothing else. So this is how these words have popped up. But on the contrary, when we talk about the rights and freedom of the citizens, it is important that the activities of government are transparent. But nonetheless, we do not get to see about such transparency of the government at any point of time. So this is again a very important move by the Supreme Court, which will at least in some manner ensure the transparency from the government. So it is relevant that the citizen shall must be knowing about the dealings of the government, about the activities of the government, so that a citizen, if a citizen will not be informed, citizen will not be able to choose the government properly. So in order to have an informed decision, in order to have an informed choice, so it is very much relevant that we shall be made aware about the activities and dealings of the government. Lastly, death penalty only if no chance of reformation. Again, in a very historic move, the Supreme Court has come forward with a new policy that death penalty shall not be given loosely. Now we have been seeing that if any rape cases happen, we might have seen that the punishment for rape shall must be death penalty, right? It shall be death penalty. So now the Supreme Court is saying that death penalty cannot be given at every point of time. So it is surprising to see that we all of us know that rapes are happening at a huge number, right? Every day or every alternative day, we come across such news of rape or gang rape or rape and murder, right? So we come across such news, but we do not come across such news where the accused of the rape or accused of the gang rape have been getting the serious punishment. So when we talk about the criminal justice system, it is to be understood that things work in a different manner. And now Supreme Court says that the purpose of the criminal law is not only to give punishment, but it is also about the reformation. So the purpose is if we keep the person in a prison, so we analyze whether there is a possibility of change or not, whether that person can reform, can do something to correct himself or not. So this is a very important issue. Now, the current case was of a 2009 where the accused killed the person. First, he kidnapped a boy who was a 7-year-old, and later he killed him also. In this judgment, the bench took the certain factors that whether to give death penalty or not. So they found out that A, convict was poor, then he did not have any prior criminal record, then he was also suffering from hypertension, and he secured a diploma in food catering while he was in prison. So all of these activities which are being done in prison is with the prominent purpose that the person shall be completely reformed and the mentality of committing crime should be erased. So because of this, certain activities have been planned in the prison, like this person did his diploma. So with this factor, Supreme Court said that we do not require him to go through the death penalty. Why? Because to give death penalty, there is a doctrine called rarest of rare doctrine. So we have seen in multiple cases that rarest of rare doctrine works. Now, rarest of rare doctrine is very much important for you to know with the examination perspective, because in the recent time, a lot of issues have happened with respect to the rarest of rare doctrine. So in this particular regard, there are few cases in which the court has said that the death penalty can only be given under the rarest of rare. So rarest of rare means when the court looks after the convict and finally agreed or is convinced that there is no scope, right? There is no scope for the convicts to grow or convict to reform. So we have seen that in the case of Yaqub Menon, in the case of Ajmal Kasab. So these people were arrested under the preventive detention law. So these people were terrorists, and court said that in that particular time that we cannot afford a chance to go through the reformatory process for these people, because these people are terrorists in nature, and there are a high probability that as soon as they move out of the court, even after 10 years, 15 years, there's high probability that they will commit this type of act again. So in order to prevent that situation, in order to consider the security of the citizens, the rarest of rare doctrine has been applied. So to see that whether the convict who is under a certain crime, who has done a certain crime, is or is able to change himself or not. So that is why it is the responsibility of every court at every level that they shall see about the person's well-being, about the person's background, and if everything matches with it, then there shall be no death penalty. So in different cases and at different points, Supreme Court had said that even though the death penalty has not been given, the time can be decided by the court. So it could be 20 years, it could be 30 years, but the death penalty shall not be given. So Supreme Court has added this line that it says that death sentence not be imposed only by taking into the account the grave nature of crime. So the court is clearly saying here the grave nature of crime is not the only criteria. As I just mentioned, that people judges from the social behavior, right? A rape has happened, or rape and murder has happened. So only the gravity of the crime cannot be seen while granting the death penalty. But when we go back to the old era, so there was a reformatory process in which the criminals have been given a chance to perform atonement. A process of atonement has been given. Even in the Vedic times, we have seen that the atonement procedure has been given, and there is no immediate punishment, right? So this is the rule of law, that we shall give chance to these people that they can reform. Of course, the crime is grave in nature, but it is important to understand the mental element of the convict also. So clubbing up all of these factors, Supreme Court in its judgment says that rarest of rare doctrine shall not be applied loosely and shall be applied after looking all of the factors about the convict and have a very proper background check, and then only a decision has to be taken. So with this, we have come to an end for the today's session. So if any doubts are there or any comments are there, please write it down. Okay, so thank you for joining, guys, and looking forward to see you in the next session.